Thanks, Mr. Pepper, for your time. I appreciate it. I won't take a lot of it, but you know me. I'm Craig Petrus. Some of you know me. Craig Petrus. I'm Director of Career Services here for the Huff Graduate School of Business. And a lot of you got to know Sarah Henning, who you're dealing with from a career services perspective, but she has left our organization to, obviously, you know, to take a promotion over at Shands, doing some things there. But I am excited to announce that we've just recently brought on board Michelle Bloom-Lugo, who's the newest member of our team. And so she's going to be taking the responsibility for managing career services for our office for the MSRE program. So she comes from a great background of both corporate recruiting as well as human resources, both from New York City as well as Gainesville, experience in you know, having 10+ years of experience in those specific areas as well. So we're excited to have her on board. She's jumped in head first, which is great. She's going to be a great resource to us and our department as well as your program. So from now until whenever, I highly encourage you all to take advantage of her time and her expertise in this area. And we can certainly help you out as much as we can in terms of finding that job or the next career opportunity for you. So please definitely take advantage of her time, and I'll have you say a few words. So.
Just a few words. I've had the pleasure of already meeting a few of you. Just going to take a few words. Hopefully we'll have an opportunity to talk and come and visit me. Just really quickly, my background is in recruiting. Most of my experience comes from New York, where I worked for a private agency, and I placed quite a few candidates in a lot of the big 4 companies, a lot of finance, a lot of law firms. My forte is in critiquing your resume, obviously, but I also think I can lend some help to you in terms of getting ready for some of those interviews. As you might imagine, I've been in quite a few interviews and read quite a few resumes. Also, I'm hoping to work closer with your department to get to know your advisory board. You guys are really lucky. You have a really good and robust advisory board to advise you and mentor you, but hopefully we'll be able to work together too and solidify more of those relationships. So I could go on for a while, but I hope that you'll come and visit me, send me an email. Again, it's Michelle Bloom-Lugo, and I really look forward to working with you guys. All right, have a great day. Thanks again.
Thank you.
Thanks. Thank you so much. Thank you.
Thanks, Michelle. See you. That's right. All right. Well, here we go again with another good trip, I think. I'm very pleased to introduce our guest for today, Steve Pepper. He's partnered with Arnall, Golden, and Gregory in Atlanta, a major law firm up there. And he's in the real estate practice group. He chairs their multifamily practice. He's in their commercial lending practice group and in their distressed asset practice group. He's a Gator twice over and has how many Gators in your family now? 4?
Yeah, my sons, my sisters, my sister, my daughter-in-law, a bunch of people, my ex-wife.
A tribe of Gators, and we're just very delighted to discover what he's up to and getting back here. He was selected, he came to our attention when he was selected to the Best Lawyers in America and the Atlanta Best Lawyers. He was named the Real Estate Lawyer of the Year for 2012. So what's he been doing brings us down. And that's not the only recognition he's received, by the way. He represents lenders of all sizes and levels in structuring and closing of commercial real estate, all kinds of terms. In fact, there really isn't, I can't find anything that he hasn't worked on in the realm of real estate finance-related legal work. He's handled workouts of several large loan portfolios in the home building industry for a large regional bank. He's led numerous due diligence teams for acquisition of large loan portfolios. And one of them that intrigues me, he regularly represents multifamily developers and owners. And in one recent transaction, he was involved with the acquisition of 15,000 units spread over 10 states and I don't know how many properties, with a tremendously diverse character in their financing and characteristics. So I can't imagine anything more complex than that. So basically, he's got an incredible number of stories he could tell. I love his topic for today. I'm so distressed, real estate loans in the modern world. Steve, welcome.
Well, thank you very much for having me, and thanks for the small group that gave up an hour of their time to let me tell stories to them. And I apologize, Tom, you were the only non-lawyer or soon-to-be lawyer, and I hope we didn't bore you too much talking law stuff. One of the first things I did learn is negotiation. When Wayne called me originally, he asked me if I could make a presentation on note sales. I know what those are, but I haven't done very many, so I did what I do in most negotiations. I ignored what the other side said and just went my own way. One of the things Wayne said that y'all would probably want me to start off would be to kind of tell you, how did I get here? You know, the accolades that Wayne mentioned, and he was so kind to mention, they're peer review things, and it's very nice, but you know, as I was telling the folks that I was with earlier, there's lots of really good lawyers. There's lots of really bright lawyers. It's a profession that actually, for all the bad press we sometimes get, attracts some of the best and brightest people to go into it. So they're peer review things, and it's flattering. But how did I get here? Well, I didn't wake up one day and say I'm going to be a lawyer and I'm going to be a real estate lawyer. I came to you. I'm at that weird phase now. I can't see you with my glasses on, and I can't read my notes with my glasses off, so I'm going to be going back and forth. I came to UF in the summer of 1973. I'm from Miami originally, and I was a freshman in 73. I was a history major, and kind of knew right away I was going to go to law school. I never once thought about real estate. And I graduated, you know, back then no one told me that the goal was to stay in college for 5 years and get your degree. So I did it in under 3 years, which I thought was really cool at the time, except I was 20 years old, I had just graduated, and I was starting law school a week later. And probably not the best thing to do. And that's why programs like yours, where people are encouraged to take a year or two off before coming back to grad school, probably a very good idea. But I decided, well, I'll go to law school right away. So I went to law school, started at the end of March in 1976. Noticed immediately that I was considerably younger than my classmates. They were actually married. I was having a hard time getting a date. And in the first day, I knew I was in over my head. So I called my dad, who always wanted me to be a lawyer, and I told him I was dropping out. And he gave me the most unbelievable pep talk. I mean, it was the night that Indiana won the national championship in basketball, the year they were undefeated, 1976. And I remember watching that game thinking, oh, I can't wait to go to law school for the second day tomorrow. And I went back the second day and sat in the front row in a room kind of like this, like a lot of the law school rooms are. I sat in the front row, the middle. Only the nerdy guys sat in the front row, but I figured I would sit there to keep awake and stay focused. And I literally, this is the God's honest truth, I had a psychological reaction in the middle of the class that I could not hear. I could see the professor's mouth move, but I couldn't hear a word he was saying. And all I was thinking was, how fast can I get to Tigard Hall and drop out of law school? So this time, after class was over, I went right to Tigard first, dropped out, then I called my dad. He was upset, but it worked out fine because I took a year off and I did all kinds of interesting things. I stayed in Gainesville most of that year. I took some postgraduate classes, law related, so that I could get a student ID card and continue to play intramural sports. And everything worked out fine. And then a year later, in March of '77, which was still a little before I would have normally graduated, I went back to law school. Many of my close friends by that time had graduated and started law school, and I enjoyed it a lot and did okay. I never once thought about real estate. It just really wasn't anything, even though my family's business in Miami they were in the land sales business, it just wasn't anything I wanted to do. I wanted to be a litigator. In 1970, I got out of law school in '79. The world was very different than it is now. We didn't have 1,000 lawyer firms. We didn't have too many 500 lawyer firms. There weren't firms that were hiring 50 first-year associates. It was much harder to get a job. And even though I had a lot of the accolades that you're supposed to have to get a good job, things just weren't going well. And I decided to move to Atlanta. I actually got a job in Miami. I worked there. This is kind of the history of my life. I have a lot of one-day careers. I went to a law firm in Miami that I interviewed for. There's a very prominent lawyer in Miami named Alberto Cardenas, who who had run for Congress against Claude Pepper and was really the darling of the Cuban American Republican Party then, and he interviewed me and told me he was starting this new law firm with 4 other guys, and I'd be their first associate, and they'd have 30 lawyers in a year, and what a great opportunity this was going to be for me. And I accepted the job. I was newly married, and I was supposed to start in 2 weeks, and I got there 2 weeks later, and the 5-lawyer firm was down to 3 lawyers. And I knew that was not a good thing. And they gave me, I was a litigator, and they gave me 20 files and said, these are your files, go through them, and we'll talk about them later in the day. And all right, so I opened up the first file, and every single piece of paper in the file was in Spanish. I don't speak Spanish, so I put it to the side. And this went on 3 or 4 times. And I walked into the partner's office, who was the litigation partner, and I said, Mark, I've gone through 4 files, they're all in Spanish. He said, oh, everybody in this office is bilingual. And I said, well, I'm not. He said, well, don't worry about it. Find ones that are in English. So I found one that was in English, and I knew enough to know when I was going through it that the next day at 10 o'clock in the morning, he had a hearing to defend a summary judgment motion in the Circuit Court in Dade County. And I went and I said, Mark, you know you have a hearing tomorrow. And he said, I told you these are your files. You have a hearing tomorrow. This is my first day practicing law ever. So I spent the rest of the day preparing, and I went to Circuit Court in Dade County, and it was in the judge's chambers, and it was a calendar call, and the judge called the case and said, whose motion is it? And the other lawyer said, it's mine, Your Honor. He said, let me hear your argument, and he made about a 1-minute argument. And in my head, I'm going, I can handle that, I can handle that, I can handle that. But before I could say a word, the judge looked up and said, motion denied, next, which meant I'd won. But I knew something was, I knew something was wrong. So I went out into the hall, and I called my young bride and said, she said, how'd you do? I said, I won, but when I go back to the office, I'm quitting. And she said, what are you talking about? And I said, well, I worked too hard in law school, and this is not where I'm supposed to be. For some reason, I can't find the job I want in Miami. Let's look in Atlanta. So she was young and willing to do what I would tell her back then, and we moved to Atlanta. And I wanted to be a litigator, and more specifically, I wanted to do securities enforcement litigation. You're wondering where this is rambling. It's going to get to real estate, I promise. I wanted to do securities enforcement litigation. And I sent 40 or so resumes to firms in Atlanta, and I got a pretty nice reception. And I went up and interviewed for a week, and I got 2 job offers. Remember now, I wanted to do securities enforcement litigation. I got one offer from the United States Securities and Exchange Commission to do securities enforcement litigation for $22,000 a year, which, believe it or not, was a really good salary. And I got an offer from the 3rd largest law firm in Atlanta, which was at the time was called Hansel Post, to do commercial real estate, which I had never thought about and had no idea really what you did when you did commercial real estate. I'd taken a couple of classes at Florida, the mandatory property class and one other. But they were offering me $24,000 a year, and you know that's the how-to interest thing right now. You make silly decisions when you're young, but I made that decision. I said, for $2,000 more and working for this big firm, moving to a new city, I'm going to do commercial real estate. So I went there in September of 1980, and I went in the first day, and they were the biggest, most prestigious real estate practice in the Southeast. Every major transaction in Atlanta, every skyscraper that was built, or every shopping center that was done, they had a hand in somewhere. And they gave me a file the first day and said, read this document. And it was a document called a deed to secure debt. Now remember, I'm from Florida, and I had no idea what a deed to secure debt was. I didn't know at the time that only Georgia has deeds to secure debt. So I read it was about a 50-page document, and I read about 5 pages of it, and I said, this is kind of like that thing we have in Florida, that mortgage thing. And that's when I realized it was a mortgage. But I spent 14 months there. As I was telling the guys before this, I was unhappy for 13 and a half of them, but I learned a tremendous amount. And from there, I've moved on to 2 or 3 other firms that were big, and things have gone well for me, and it's been a great career. And so a lot of interesting things happened, you know, and when I got the call from Wayne to make this speech, and he said, you've been named a distinguished alumnus, we'd like you to make the ring speech, I did what everybody does when they get an honor. I went on the internet to find out what that meant. And I saw that the last speaker in the spring had been Howard Gutman. Well, Howie was in my pledge class at Florida, so I sent Howie an email. He's in the real estate business in Naples. Some of you may have seen him speak last year. And I said, what's this Ring Distinguished Alumnus thing, and what did you do? And he said, oh, it was great. I spent a small group session, and then I spent an hour and a half, 45 minutes just talking and answering questions. I said, oh, okay, fine. And then he sent me an email that I thought was particularly funny. He said, who would have thought in September of 1973 that the word distinguished would ever be used in front of your name or my name? So that's enough about me. So Wayne gave me the opportunity to really talk about anything I wanted to talk about, and I decided that something that what I would talk about would be distressed real estate loans. And by distressed real estate loans, I mean issues, things that we see, and I apologize in advance if this is more slanted towards the legal side of commercial real estate loans, because that's what I know. I have a history degree. I never took a finance class in Florida. I took accounting pass-fail from Dr. Anderson in the basement of Matherly Hall in 1975. That was my whole time in the business college, except, well, I took economics twice. Florida used to have a thing where you could get grade forgiveness on one grade in your 4 years. They got rid of that. Because I was rushing through college, I took economics, the basic macro class, my first quarter at Florida, and I didn't get an F because I didn't give Fs. I got an E, which was really shocking to me, and I got to throw it out under the grade forgiveness policy, and took it again with Dr. Goffman, who fortunately was also my fraternity's advisor and managed to somehow get a B, so that worked out okay. So I don't know anything about development, the financial part. As I was saying, that's something you all really should focus on. It's a skill set that no matter what you do in real estate, if you're a developer, a lender, if you're in the leasing and management field, if you're, any aspect of it, the more finance knowledge, particularly real estate finance knowledge you have, the better it's going to be. But let's kind of set the stage. If I push this thing, it'll. No. Let's try this. Let's try that one. I also never took any classes in technology when I was at Florida, so maybe we have to aim it here. Okay. Well, I'm going to wing it because I have it in front of me anyway. So the we're going to talk about it in when we talk about a distressed real estate loan, we're talking about we have a project, we have financing. Everybody had the best intentions when we started, but now we've gone down a year or two, and things haven't worked well. Many things could have happened. We could have a global worldwide recession. You may have read about that one in the paper. And so suddenly the borrower and the lender are in a situation where they got to figure out how they're going to get out of this. So we have to pick a project. There are lots of different segments in real estate, and the way you would handle a distressed real estate loan is going to depend oftentimes on what your project is. And when I talk about that, we're talking about multifamily or industrial or office or retail. They all have different specialized components that I'm not going to get into, but overall, the relationship between the borrower and the lender is already existing because of there's a set of loan documents that a lawyer for the bank and a lawyer for the borrower have spent a lot of time negotiating years ago, and when everybody thought this is a can't-miss project. So what are these documents, and why are they important? Well, obviously, you're going to have a promissory note, which is going to be the document that evidences the debt. It's going to talk about the amount of the debt and the repayment structure and the interest rate and all those sort of things. And it's going to be one of two kinds of promissory notes that you're probably familiar with. It's either going to be a full recourse note, or it's going to be exculpated. And by that, we're talking about it's either going to be a loan where the borrower has personal liability for the repayment of that loan, full recourse, or we're going to talk about a loan where that's fully exculpated, and where the lender's only recourse is against collateral. He doesn't have a right to go personally against the borrower. And that's the way things always were when I first started practicing law back in 1980. In the interim, there's been a whole evolving part of the practice, which is carve-out liability. Essentially, lenders, 25 years ago realized, well, I'll make this guy a non-recourse loan, but there are certain things that even a fully exculpated borrower should be liable for, often referred to as bad boy carve-outs. And it's things like misappropriation of rents. So you're buying a shopping center and you're collecting rent from your tenants, but instead of taking the money and paying your lender, you're buying a car, or you're going to Europe, or you're putting it into a Swiss bank account. It's a non-recourse loan, but if you've misappropriated rents, it's going to fall into a carve-out, and you're going to have liability. And that carve-out liability has evolved over the years. We used to have 3 or 4 things you'd have carve-out liability for. Now you can get an exculpated guarantee that has 10 or 12 pages of numbered items. You get to number 58 of things that you have liability for. And then someone said, well, all these bad boy things we want you to have liability for, but there's some really bad things we want you to be fully liable for the loan if you do these things. The biggest one always being filing bankruptcy. I mean, in pretty much any non-recourse loan today, if the borrower files bankruptcy or the guarantor files bankruptcy, the loan becomes full recourse, even if it's non-recourse, and it's springing and it's irrevocable. So a lot of borrowers who have loans that are guaranteed by individuals are going to be a little bit reticent to pull the trigger on filing bankruptcy in a lot of situations if they know it means personal liability for their principal. So we have this loan, and the next part of it we have to figure out is, okay, well, what's the nature of the default? And I'm just, okay. Two big kinds of defaults that we're talking about generally. Monetary defaults in broad numbers and non-monetary defaults. Monetary defaults are exactly what you would think they would be. Failure to make the payments required under the terms of the note. Most lenders will not give you any right to cure that default. It's your one obligation under the note is to pay. They may give you a grace period if you forget to pay, a 5 or 10 day grace period if you have a good lawyer who negotiated that in for you. And then you have non-monetary defaults, and those are essentially breaches of any other provision in any other document. So, I mentioned just a few documents to start with. The note evidencing the debt, a guarantee that guarantees the debt from a third party, somebody of means or an entity of means. But in a typical commercial real estate loan, there's 20 documents. You're going to have your mortgage document in Florida, or in Georgia, your deed to secure debt, conveying the property as collateral for the loan. You're going to have an assignment of rents and leases, an actual assignment of the cash flow coming out of the property as collateral for the loan. You're going to assign all kinds of other ancillary documents. For instance, if it's a construction loan, the borrower may have a construction contract. He may have an architectural contract. He may have a listing agreement with a brokerage company to sell condominiums. The lender wants to make sure that if there's a default, the lender gets to step into the shoes of the borrower and enforce that construction contract, make the contractor perform for him, make the architect perform for him. So you'll have an assignment of contract documents. When I first started practicing, we didn't have an environmental document. We didn't even have the word environmental in loan documents anywhere. But over the ensuing years, that's a big part of life. You're going to have an environmental indemnity agreement with lots of environmental representations that you're all going to see in your career at some point about things the borrower has not done, such as bring hazardous materials onto the site or onto adjoining property, and most importantly, including an indemnity in the event of any loss that the lender incurs as a result of environmental violations, because lenders are scared to death that they're going to get the proverbial tar baby. And they're going to go back and foreclose on property only to find out that somebody messed up and the groundwater's been contaminated by petroleum product or dry cleaning fluid or any of the things that you probably won't take a class in here, but that's what happens in the real world. People pour dry cleaning fluid down the drain and it gets into the soil and then it gets into the groundwater, and then you have a cleanup, and cleanups never cost less than 6 figures and usually don't cost less than 7 figures. So lenders don't want to be in that situation if they foreclose, so you're going to have that. You'll have your assorted affidavits and things about the title of the property. You'll have things required by federal law, like under FIRPTA, which is the Foreign Investment and Real Property Tax Act, you want to make sure that your seller, if he's a foreign person, is not taking all the money out of the country without paying his income tax on it. And so you'll have disclosure documents on that. But essentially, any of these documents, and you'll have a loan agreement, which is like the Bible in your transaction. It'll have all the covenants of both affirmative and negative covenants, things the borrower can and can't do. It'll have pages of representations and warranties, which essentially is like a checklist for the lender. We want to make sure the borrower has done his homework, and so he can make a representation that the property is properly zoned, or that all permits necessary to construct the shopping center are in existence, or utilities suitable to develop the property are existing at the boundary line of the property without any additional tap-in fees. Things that are just common sense when you think about them as a business person, but you have to put them in a loan document in order to be able to enforce them if they're not true. So any of those things can turn out down the road to not be true, and those would be non-monetary defaults. Most lenders, if you do a good job negotiating, will give you an opportunity to cure a non-monetary default to the extent that non-monetary default can be cured. And let me give you a good example of one. Every mortgage document that you'll see in a sophisticated transaction or the corresponding loan agreement is going to have a requirement that the borrower provide insurance, all kinds of insurance on a property. You're going to have an obligation to provide liability insurance for injury to third parties on the property in which the lender is named as an additional insured, casualty insurance, fire insurance, to ensure that there's a source of proceeds if you have a fire, a flood, a tornado, whatever it is. You may have loss of rents insurance, like a business interruption insurance that is required by a lot of lenders to make sure that if there is a casualty, there's an insurance company that'll stand there and essentially replace the income stream that you were getting from your tenants that paid your rent. So let's assume a basic one. You have this insurance, you have a covenant to provide insurance, and you're not allowed to let it lapse, and you're supposed to pay the premium, and you're supposed to provide the lender notice that you paid the premium timely, but you forget to pay it. And now all of a sudden the insurance has lapsed. Well, a lender does not want to be in that lapsed position, because if there's a casualty in that position and they're uninsured, they are SOL, as we say. So people are going to, that's a non-monetary default. Will a lender give you an opportunity to cure that one? Yeah, they may give you a short period of time. I will tell you a Supreme Court case in Georgia that I always think about how serious some people take this. There was a covenant, and it provided to provide insurance, and that the lapse of the insurance would be a default. And through inadvertence, the borrower allowed his insurance to lapse, and he realized that the next day, the lender received a notification, because part of insurance is that you have a list of people in your policy who will be provided notices of non-payment. In addition to your borrower, you'll designate your lender. The lender got the notice the same day that it lapsed, that the insurance had lapsed, and the next day he started foreclosure proceedings. He accelerated the loan, and he started foreclosure proceedings. The borrower went right in the second day and replaced his insurance, and there was no casualty. And so in the foreclosure, which in Georgia, and I'll talk about this a little bit later, is very streamlined. It's non-judicial. You don't go through a court to do it. You do it on your own. The borrower filed a lawsuit to enjoin the foreclosure on the theory that no harm, no foul. Yeah, my insurance lapsed, but there was never a casualty, and I replaced the insurance before a casualty, and so therefore this shouldn't be a default. And the Supreme Court of Georgia said, sorry, you had an obligation to provide the insurance, you let it lapse. The lender never bargained to be put in that risk position. He properly accelerated before you reinstated the insurance. Therefore, he can foreclose and take your property from you. Now, kind of an extreme example, but it's the kind of thing that lenders are, when you're talking about non-monetary defaults, those are the sort of things you'll talk to. I put on the list financial covenants. I'm not going to get into that too much. I'm sure that you'll be taking classes in certain aspects of real estate finance where there are things that metrics that lenders use to determine the viability of a loan, things like debt service coverage ratio, the ratio of income to the amount of money needed to service the debt on the property. You may have to stay above a certain constant, 1.2 to 1 or something like that, below which the lender deems it too risky. And because when you get a loan, you've got a bunch of different components. You have the pricing, what your interest rate is, And it's a big calculus of going and saying, well, with a debt service coverage ratio of X, I can bring the interest rate down to Y. But if the debt service coverage ratio was worse, then I can't bring, maybe I have to charge, I have to pay myself for that higher risk. And the way I'm going to do that is to get more interest, or maybe I'm going to get a fee. Maybe I'm going to have an interest rate that changes upon not meeting a certain debt service coverage ratio. So there can be any types of, there can be numerous different kinds of financial covenants that a lender in underwriting the loan, because remember, the part that most of us never see, unless some of you probably have worked for banks, is that the borrower has the relationship guy in his life. It's his real estate relationship guy. It's the guy that takes him to play golf. It's the guy that takes him to lunch. You know, it's the guy that wants his business and is so enthusiastic about his project and tells him that, you know, we're going to loan you $15 million and here's the interest rate I think we can do and blah, blah, blah. That's the guy that the banker sees. The guy the bankers don't see are the credit people, the underwriting people, the people that are sitting in the back rooms with spreadsheets doing detailed, complicated analysis of whether, does this make sense, this project at all? Is it going to work? And what are we going to require? And that's where the terms of a loan are generated. The guy that sells the loan isn't telling you the terms. He's giving you some ideas, but in terms of what they're going to charge you for the loan and what they're going to charge you for interest and the repayment structure and whether you have the right to renew it after a period of time and financial covenants, that's some other guy. So these are all the kind of things that can, any of these things at any point can go into default. So we're still trying to work out this loan. Well, another thing that's really important is just the human element. First-time borrower with a bank, nobody knows him except for the one guy that brought the business in. He's suddenly not as popular in a loan default situation. Major regional national developer who's done 40 loans in the billions of dollars over 20 years, who has a problem loan, he's going to get treated better. So the relationship part of real estate lending is a really important thing. And when you are out in the real world practicing and whatever you do, you're going to find how important that part of real estate is. It's the part they never talked about in law school, I can tell you that part, but it's a big part of law practice also. So how do we start? Typically we would start, if I'm representing the lender, I'd get a call from my client and he'd say, they didn't make the June payment and we talked to them and they didn't make the July payment. And they've got all these plans and they're getting ready to, they think, to sign a tenant with linens and things. It's going to really make a difference, but they haven't gotten that done yet. But we're kind of keeping this in abeyance for the time being, but be aware, pull out the loan documents and be ready just in case, you know, we have to move fast on this. And then 2 weeks later you get a call that says linens and things went across the street to another shopping center, so they got this 15,000-foot bay that's empty and no revenue being generated from it, and they missed the August payment now. We need to take remedial action. So the first thing we do is we send out a demand and acceleration letter. You know, the demand is just what you think. It says pay us, but I say in a lot more words because I can get paid a lot more by saying it in more words. The acceleration part is really interesting that people don't think about. If you have a 5-year loan and it calls for level payments of principal and interest monthly over the 5-year period, at any point in time, all you owe is that 1 month payment, right? So if the lender just said you're in default, cure your default, and all you had to do was pay your 1 month payment, well, you could probably scrape it up. You might have to go to your family, whatever. But what almost every promissory note allows, and some states allow automatically without notice, is acceleration, which means everything, the entire principal amount of the note, becomes due right away. Gives the lender tremendous leverage because now the borrower can't just pay you the one payment he missed. He legally and theoretically has to pay you the full $15 million if he wants to stop remedial action. So it's a leverage point. But we'd send out a demand and acceleration letter saying, you know, we represent the bank and you've failed to make the payment, and as required by paragraph so-and-so of the document, we're giving you notice and pay us or we're going to take remedial action on this date. Oh yeah, by the way, as provided for in your note, we've accelerated it. And as of today, here's the balance you owe us. Principal, interest, late fees, unpaid attorney's fees, other fees that you may have under the loan documents. We may have had an appraisal done in the interim. We may have had an environmental audit that you've agreed in the boilerplate of your loan documents that you're responsible to pay. So we tell you all that. And then we do something else that we call a strict compliance notice, because even though you'll learn in business and in law school that it's what's in the contract, the written word, parties by their conduct can modify a contract without doing anything in writing. And if you fall into that trap as a lender, you can find yourself in a situation trying to take remedial action, and the borrower going to court saying, whoa, 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 I know that my payment was due on the 1st every month, but for the last 3 years, I've made my payment on the 4th every month, and he's never done anything about it. And in Georgia, courts will say, well, you've effectively modified the terms of your relationship by taking those things. So we can fix that with a notice. We give a notice that says under a certain statute in Georgia, the lender's demanding strict compliance with the terms and conditions of the documents. And we kind of put it back on track so that he can't come back and assert that. And then we have a really, really extra clout in Georgia, and I put attorney's fee notice. Everybody's loan documents provide that they're going to pay the lender's attorney's fees. And most people think of that as, well, I'm going to pay his attorney's fees. So if he hires a lawyer to take remedial action against me to foreclose and it costs $8,000, it costs $10,000, I'm on the hook for that. But we have statutory attorney's fees in Georgia, one of the few states that does. We have a statute that literally says that if in a note there's an agreement to pay reasonable attorney's fees, here's what reasonable attorney's fees means. And it tells you that reasonable attorney's fees means 15% of the first $500 of the debt and 10% of the balance. So do the math. You borrowed $100 million from somebody, and you have had a bad lawyer representing you who allowed a standard attorney's fee provision in there, and all of a sudden, you're looking at $10 million of attorney's fees. It doesn't go to the attorneys, unfortunately. It goes to the bank. But it's nothing but a chit. It's a leverage piece that you can negotiate. And you can, once again, draft around that as a borrower by putting in language that says, I agree to pay reasonable attorney's fees actually incurred at standard hourly rates without application of the statute, which some good lawyers do. Some lawyers don't do that, and they get in that situation. But the attorney's fee notice is something we would always say. We would say, pursuant to the statute, we're making demand for the attorney's fees also. And if you pay us within 10 days, which is what the statute says, you don't have that obligation. But if you don't pay us within 10 days, we're going to go after you for the attorney's fees. So now you've demanded, you've accelerated, and all of a sudden your phone starts to ring. It's going to be the borrower calling you, the bank directly, or it's going to be the borrower calling your borrower's lawyer calling you directly, or it's going to be my favorite one, the borrower calling me directly representing the lender, and that's the one I get to say, I'm sorry, I can't talk to you because you're represented by counsel, and that would be unethical of me, so go hire a lawyer to, go get your lawyer to call me. And you're going to go into what in the big term, we call it just a workout, and it really is nothing more than that. We're going to work out our problems. And there's a bunch of different things that, and this is, I apologize for the size of this, yeah, I guess you can see it. One of the first things that we will always do, and that most lawyers that represent lenders that are doing their job right will do, is they'll say, look, before we'll even talk to you, we have to have a pre-negotiation agreement. It's a letter typically. It's a page and a half to 3 or 4 pages, and it's an important document because the first thing a borrower wants to do is come into you at 6 months into a workout and said, but you told me this, or you promised me this, or you said I could do this. And the lender is going to say, no, I didn't tell you that, and you're going to get in that kind of situation. What the pre-negotiation agreement does is it kind of establishes the groundwork for the negotiation of the workout. And the way I've set it up on the PowerPoint is that everybody's interests aren't the same. The borrower's interests in a pre-negotiation agreement aren't the same as the lender's. So that's kind of a list of different things that might be important to different people. So for instance, on the lender side, the first one on the right, one of the things lenders are always afraid of is a counterclaim for lender liability. There's a detailed, evolving body of law where, based on actions lenders have taken, typically involving control of projects, but other things also, courts have hit lenders with big damage awards for lender liability. Lenders don't want to go. A lender does not want to negotiate a workout with you, only to find out that once the workout's over, the first thing you're going to do is sue them for some lender liability claim. So, from the lender's perspective, one of the things he's going to want to do in a pre-negotiation agreement is to incorporate a waiver of claims, where the borrower will say that I have no claim against you, and move forward. The borrower, on the other hand, is going to say, look, I just want to work out my loan default. I'm not interested in waiving any claims against you. I don't think I have a claim against you, but why should I be in this situation where I have to waive a claim against you that I might have in the future merely to enter into a negotiation, not to enter into an agreement to resolve our problems, just to negotiate with you over this. And so, pre-negotiation agreement, which literally I can prepare in, don't tell anybody I said this, I can probably prepare it in 4 minutes if I'm moving well. Sometimes we'll take 2 weeks of back and forth and ridiculous negotiation between borrower and lender's counsel over the most inane points. But eventually you get the pre-negotiation agreement in place. And now, as a lender, you're willing to go forward. So what do you do right away? Well, you have all these documents. Well, one of the things that banks do that's really interesting is they have divisions of labor. And so when a loan becomes a bad loan, it typically gets moved from the commercial lending or the business lending group that it was in, the guy that played golf with you, and it gets moved to my favorite acronym of all time, SAD, Special Asset Division, Special Asset Department. You'll hear a lot of people say, what do you do? I work at SunTrust, I'm a SAD officer. Doesn't mean they're unhappy. It just means that they work in special assets. Totally different mindset. They're not interested in being your friend typically. They're only interested in protecting the bank. They're only interested in minimizing and mitigating loss, recovering as much for the bank as they can possibly get. Sometimes they recognize that the way to do this is to work with you to extend your loan because you have the best chance of, by operations, of working out of this problem. Other times it's really just to stall for some time before they take remedial action. But because you're switching groups, especially in a big bank, you're typically also switching lawyers. So the lawyer that, a lot of banks will have a policy that says, if Steve represented us in closing the loan, we don't want Steve or his firm representing us in workout of that loan. They seem that doesn't make a lot of sense and it's inefficient to do it that way, but it's just human nature. If Steve and his firm messed up in drafting loan documents, when they're going through the loan documents and they realize that during the negotiation, suddenly human nature puts you in a really tough situation. What do? Do I worry about the mistake that I might have made or something I could have done differently? Or do I just do what's in the best interest of my client? Well, you'd like to think, and I think most lawyers would err in favor of their client, but lenders don't always see it that way. So they're switching, a clean set of eyes. They don't know anything about the documents. They're not their documents. And so the first thing that you're normally going to do and work out is a collateral audit. And I know that Wayne mentioned that I had led a due diligence team a few years ago, and this was, a classic situation. We represent SunTrust Bank. It's a big regional bank. SunTrust Bank bought another bank called Gainesville Bank and Trust, which was a holding company for 7 or 8 community banks located in the northern suburbs of Atlanta, 4 or 5 on the west side of town towards Gainesville, on the east side of town towards Gainesville, 4 or 5 on the west side of town. Little banks. Little banks often use little lawyers to close loans. Little banks often don't use lawyers at all to close loans. Little banks use form documents that they buy from loan document companies. Little bank guys often don't read little loan documents. And so we had 300 in this portfolio that SunTrust bought. In these banks, there were 300 non-performing commercial real estate loans. This is 300 loans that were in some shape or form of default. But SunTrust said, we have no idea what we have. So we took a team of 7 people for a month and they went out to the banks and literally stayed there all day, and there was mostly younger lawyers, so you guys will be doing it in a few years. Literally pouring through loan documents, abstracting every document, looking for the things you have to be able to take remedial action, seeing if the documents were infirm in any way. And that's what a collateral audit would be. You would review your loan documents, you'd look at your title documents to make sure that you have a properly perfected security interest in the real estate. To the extent you have non-real estate assets like personal property, equipment, you'd make sure that you've properly perfected under the Uniform Commercial Code so that you have that collateral. Because these are all lines of defense eventually. If you are not properly perfected, the borrower is going to assert that as a defense. You're going to look at the environmental stuff. You're going to look at authority documents. You know, it's something that a lot of smaller banks take for granted. ABC Inc. comes in to borrow money, and Bob is the president. He tells you he's the president of ABC Inc. And so they make a loan to ABC Inc. and the documents are all signed ABC Inc. by Bob, president. And he goes and he gets you a certificate of good standing from the Secretary of State, and you move forward. Well, that's great, but what if a little more due diligence would have revealed that in the bylaws of the company, there are restrictions against borrowing unless loan documents are signed by 2 officers, one of whom is an executive officer. What if it requires shareholder consent, and there's 15 shareholders, one of whom lives in Alaska, and no one's even told them that they're borrowing the money? These are all things that would make potentially mean that the loan wasn't properly authorized at the corporate level. I think in law school we called it ultra-virus or something like that, if I remember correctly. So you're going to look at authority documents, and we don't see too many corporations anymore. The entity of de jure entity, of course, is limited liability companies. Easy to form, one piece of paper, you can form it quickly, provides a full liability shield, just like a corporation, but a lot easier to deal with. And from a tax perspective, it's not recognized for tax purposes. So you're not paying tax at 2 levels like in a corporation. You'd be paying at a corporate level and then the distributions to the shareholders. So that's pretty much the real estate. Used to be limited partnerships, now it's limited liability companies. And then you're going to look at other things that may be in the loan file. What did you know about the borrower going in? How many other projects did he have? What's the condition of those projects? Are they all in distress? Who's the guarantor? How many loans has he guaranteed? Is this $15 million loan his only contingent liability? Or does he have, as I was explaining to the group before this, does he have $80 million of contingent liability, which one of my best clients had going into 2008, and when the music stopped in 2008, he got left holding the bag on $80 million that he's still trying to work his way out of bankruptcy on. So you go through that and get a handle on what you can do, at which point the borrower is coming to you and saying, okay, I want to, here's what I want to do. This is all I want to do. I know my loan matured a month ago, but I want you to extend it for 3 years. I'll give you a little bit of money to pay it down, but you need to reduce my interest rate. Oh, by the way, I only want to pay interest only for the next 2 years. You'll get that, and then you'll get the response. And the response is never, sure, we're willing to do this. It's going to be more like, no, as a matter of fact, we made you this loan in 2005 at an 85% loan to value. Well, we don't underwrite loans at 85% anymore. We're underwriting at 65% to our best customers. You're not our best customer, though. So we'll go to 60% loan to value for you, which means as part of this workout, you need to come up with $2.5 million of equity to pay down the loan balance, or else we don't see any reason to move forward with you. That's the real world, what we're seeing now. Oh yeah, by the way, we know you borrowed it at a LIBOR plus 180 basis points in 2005. Well, we don't make LIBOR plus 185 basis point loans anymore. We'll make you a LIBOR plus 350 basis point loan, and then you're really thinking in your head, well, that's not a big deal. I mean, LIBOR was over 3% in 2005. Today, LIBOR is under 1%, 30-day LIBOR. So I'm doing better. They go, oh, but by the way, you're going to have a 4% LIBOR floor. So no matter what LIBOR is, you're starting at 4. We're adding the 300 basis points or 350 basis points. So you're at 7.5%. Well, suddenly Does it make sense? Does it work? Do you have enough cash flow coming out of your shopping center, or you're to service that kind of debt? How much money you're going to have to come out of pocket every month? So all this goes into this, giant hodgepodge of decision making. But eventually, hopefully there'll be some agreement. And often the agreement is, the leverage is often the guarantee, because banks traditionally aren't making non-recourse loans. They weren't making non-recourse loans even before the recession. Non-recourse was the province of insurance companies, the CMBS world, the collateral mortgage-backed securities world, where people were going in and getting non-recourse loans with those bad boy carve-outs. But most banks, they have somebody where they want them. They have somebody. They have a lot of leverage over somebody, and so even though they have to go figure out where to get the cash, and even though the interest rate's going to get jumped up on them, it's better than losing the property, or even worse, being sued for $15 million personally. Because in almost every loan document, in almost every state, lenders can make an election of remedies. They don't have to do one thing or the other. We saw back before the recession, it was very easy. Everybody foreclosed in Georgia. And I'll get to that in a little bit, because our foreclosure process was so streamlined that you literally could go from thinking I want to foreclose to owning the property with no right of redemption in 45 days if you hit the calendar right. But coming out of the recession, because there were so many loan defaults, lenders are thinking, do I really want to own that property? I've got enough owned real estate. What am I going to do with it? I'm going to sell it. It's not worth nearly what I thought it was worth when I borrowed against it. So now their first line of offense remedially is they're suing on the note, and they're suing on the guarantee. And they're saying, let me get a judgment first against the guarantor, which is a much longer process. It's a court process. It's painful for everybody, but you get the judgment. And when you get the judgment, maybe you don't touch the shopping center. Maybe you're going after the Merrill Lynch account he has that you can get a judgment lien against, or the boat, or the car, or anything else that's not protected, either like in Florida where homesteads are protected unlimited, or 401ks, which would be protected. So, but what you're working towards normally is a forbearance agreement, and a forbearance agreement is essentially a fancy loan modification document. On the one hand, the lender is saying, I will forbear from taking any remedial action against you as a result of your default, and in exchange for that, you're going to do the following. And this chart again kind of shows you some of the borrower-lender different things, but it's the place where if you're going to change the interest rate, the lender's going to charge you more interest, it's going to be in the forbearance agreement. If you're going to be paying a fee to buy a forbearance period, it'll be in there. If you have certain sale requirements or obligations, I've done a bunch of workouts in the last year in the single-family world, not single-family houses, but big developers who borrow $20 million to buy 500 acres and then develop it into developed lots that they sell to home builders. And when the music stopped, no one was building homes, and they got left with lots. I mean, SunTrust at one point had owned real estate of over 7,000 single-family lots that they took back in foreclosures in the early phases of the recession. They're not taking them back as quickly anymore. So you go through the process of negotiating your forbearance agreement. The big negotiation points are going to be, how long are you going to forbear? Because literally that's all it is. It buys you time. Because every borrower thinks, especially a building borrower, they think they can build their way out of debt. In the home building world, especially those guys who owe $20 million on their acquisition and development loan, they believe, if you'll just give me access to my money and let me just keep building houses, I will eventually sell enough of these houses to pay everybody. But in this economy, that doesn't happen anymore. So you're arguing over, we're going to give you 6 months, we're going to give you a year. I've never seen one more than I've seen maybe 2 years once, but not too often. And as a business person, and I'm assuming that, I look at all of you and I see clients, actually. I mean, someday I think many of you would be people I'd want to pursue to get business from, I hope, except for the guys that are lawyers. And you have to know who you're dealing with. You know, so many people are in the loan workout world now, whether it's with banks or special servicers that are servicing pools of CMBS stuff, where there's thousands of loans in default, and this year, I don't know how many CMBS loans are coming due this year. There was 5-year loans that were made in 2007 before the recession are all coming due this year. 5-year loans from 2006 all started to come due last year. So there's a tremendous number of loan defaults on that CMBS piece, and a lot of workout. But you have to find out, who are the decision makers. You don't want to get stuck dealing with somebody that's just got his master's degree at the University of Florida, and he's working for a special servicer. It's his first week there, and he's assigned to your thing. He can't make a decision. You don't want to spend 2 weeks negotiating with him. You want to get to the decision makers. But sometimes the negotiations fail. Through the best intentions of everybody, they fail. And that's when remedial action is taken. And you have all kinds of different things in loan documents or at law that a lender may choose to take. I've already mentioned, obviously, you can always sue under the note and the guarantee. It's becoming more and more prevalent. You may decide to foreclose, and depending on the state, in Georgia, as I mentioned, it could be 45 days. In Florida, you have to file a lawsuit. You're going to have a hard time getting foreclosure done in less than 6 months, probably longer because the dockets are really backed up. But you may elect to, if you're a lender, to go get a receiver appointed. Essentially, your documents are always going to provide for the appointment of a receiver as a remedy. State law is typically going to provide a remedy for the appointment of a receiver. And essentially, it's an equitable action. So instead of suing the borrower for money, you file an action saying that we don't have an adequate remedy at law right now, so we want a receiver appointed. We want an independent, qualified person to come in, not to be the receiver for the borrower or the receiver for the lender. He's going to be the receiver for the property. We want him to step in and take over the property. We don't want the borrower being the one that collects the rent anymore. We don't want to rely on the borrower to do the deferred maintenance that has to get done, or to pay the insurance, or to haul the trash, or to pay the water bill. And so this person will step in and run the property. It pretty much pulls the borrower out of it because his access to any cash on that property is gone, but all of his liability remains. I had a client who had a loan in the CMBS market that he had refinanced an apartment property in Metro Atlanta, a big apartment property, and he defaulted in 2008 in the recession on this property, and he had a non-recourse guarantee on that property. And we thought, great, he has a non-recourse guarantee. He's protected. Well, obviously, some of the carve-outs that we negotiated was that he was personally liable to the extent we misappropriated cash, the one I talked about. But he was also personally liable to the extent he failed to pay property taxes. He was personally liable to the extent he failed to maintain insurance to the extent of any loss. They got a receiver appointed. And the first thing the receiver did was he came in and he said, your insurance is lapsing. Replace the insurance. Remember, we don't have access to the revenue from the property, so when he says replace the insurance, it means write a check for $35,000 to pay the insurance premium, or if you don't do it by this day, we're going to force place the insurance, which means the lender's going to go, it's always more expensive when the lender does it. And, oh, by the way, you have personal liability for whatever we pay to force place your insurance because the carve-out existed for failure to pay insurance. And so suddenly you're in a horrible situation. You're liable for all these expenses of the property that you thought that would never be an issue because you'd always have the revenue from the property to pay them. But now you have no access to the revenue of the property. You can't even get in the property. They've changed the locks in the management office. They've replaced all the people that work for your management company that you own with a new management company that's in there doing things. So that's another remedy of choice that we're seeing a lot. So these are just some of the things that we're seeing on a daily basis in all kinds of properties. And it does become, even though I said I wanted to be a litigator originally, and I'm not a litigator. I was in court that first day, and I was in bankruptcy court in Tampa one other time where I actually spoke. But other than that, if I'm in court ever again, I'll probably just be the defendant, I guess. But you know, it is very adversarial. Working in a loan workout, something that started off 2 years before as everybody's. One of the things I always liked about real estate was that it was the happy profession. I mean, it was, I'm a borrower. I want to borrow $20 million from you. I want to build this shopping center. I'm going to provide all these services for people in the community. They're going to be able to buy groceries and pharmaceuticals and get their nails done and a haircut. It's going to be great for everybody, and I'm going to make money, and my family's all going to invest, and we're all going to make money. And the lender said, yeah, that's great. We want to loan you this money because you're going to pay us, 7% on this money, and we're borrowing it from the Fed at 3%. So we're making money on this, and it's no risk. And we're going to put a big sign while you're building it that says construction financing provided by bank. And everyone who drives by is going to say, oh, isn't that great? Bank's providing money to build this shopping center so we can buy groceries. And everybody was happy. And you go to closings, and everybody used to have closings. We used to sit around a table and pass documents. We don't do that anymore. It's email. You don't see people anymore. It's another thing that's changed in the profession. But everybody was happy, and so happy that you would get a gift. You would get a little tombstone, maybe a lucite piece that said, bank provided a $30 million loan to borrower, and you put it in your office, and everyone would say, oh, you worked on that deal. Everybody was happy. And then you go to the closing dinner, which is always exciting because somebody's expense account was paying for it. So you'd see things you'd never seen before at a dinner, like a 6-pound lobster, which was a very unusual thing to see a banker order. But when the borrower was paying for it, he'd buy the order. Anyway, workouts are not happy things. People are looking at their livelihood. They're looking at their family's assets being dissipated to really low levels that they never anticipated. Bank officers are saying, can we recover, if we recover 60% of what we put out, we're going to be a hero. There's a lot of pressure because banks have to reserve for losses against real estate loans, and it affects the bank's share price. And so you have pressure from people above you that own a lot of stock in the bank, and they're saying, how come we're still on this loan? We have to reserve so much money against it, a loss reserve for it, and FDIC was in here today, and it's killing us. So that's not a happy time. But the good news is, and this is something I'm sure you have seen in all your classes, real estate is, of all disciplines, is by far the most cyclical. And that's the happy takeaway, I think, is that we've been, I don't know, anybody read A Man in Full by Tom Wolfe? You should all read it. It's the classic real estate novel. Tom Wolfe, if you've ever read Tom Wolfe, his books are always much too long, because, but they're fun to read. But Man in Full is about real estate in Atlanta. He wrote a 1,000-page book, a novel about real estate in Atlanta. But when we read it, when he wrote it in the early 90s, we identified the characters. They all had different names, but we knew who they were. We knew the developer that played football for Georgia Tech who had the bad knee. It was Taz Anderson. Taz Anderson played tight end for Georgia Tech, and then in the pros, great guy. He's a very successful real estate developer. But you would read that. It was a great profession. Things we couldn't lose in Atlanta. It's our only industry. We produce nothing in Atlanta. Okay, we don't build things. We don't man it. We don't have Silicon Valley. We don't produce a thing. We're a service economy, and our biggest industry, from when I moved there until 2008, was real estate. Every major national real estate, international real estate company was in Atlanta. Everybody was building in Atlanta. You couldn't lose money in Atlanta. And now it's not the case because it's so cyclical. And we're in a down cycle now. And now the big question is, everyone's saying, have we hit bottom, or are we on the way up? Well, who knows? It's just economist mumbo jumbo, and no one really knows when we're out of it. But it's going to come back, and there's going to be a lot of opportunities for people that are educated, because it really used to be a good old boy profession. I mean, a lot of people went into real estate really, because they couldn't figure out what else to do coming out of college. They had their bachelor's degree in business administration or marketing or even finance or accounting, but they couldn't get a job as an accountant anywhere, or they didn't want to be an accountant. People gravitated towards real estate. They became salesmen, and they became property managers at the entry-level jobs. And then they flash back 20 years later, and they own shopping centers and were doing great. But today's successful people in real estate, the young people that I see in deals, and I don't want to sound like the old guy, but I'll be 57 next month. I don't know how that happened, but almost every deal that I get involved in now, it's unusual for anybody in the deal, lawyer, banker, borrower, to be older than me. And it's very usual to have people that are not 30 sitting at the table with me with degrees in finance or real estate. And so there's a tremendous amount of opportunity for you, especially I think with your master's degree, and especially if you focus on getting a really sound financial base for it. That's a lot of stuff I'm sure was pretty boring for you. Only the guys that are going to law school I saw taking notes, so I'll be happy to answer any questions about anything I said or any other aspect of law practice, distressed loans, real estate in general, or not. So you're talking about the borrower's defaulted, but the lender hasn't foreclosed, and the borrower just abandons it? Mm-hmm. Mm-hmm. Well, I mean, that's the biggest problem that Florida has, obviously, is that so many loans in the last 10 years were not properly evidenced by documentation. So in the CMBS world, where the loans originated by one person, sold into Wall Street, broken up into pieces, put into pools, but no one's ever signed, no one's ever executed a document assigning interests in the mortgage. That's why you have that injunction that stopped all foreclosures in Florida. But in your situation where the borrower just decides to abandon the property, lenders always have a right under their documents to come in without foreclosing and taking possession. We would never advise a client to do that who is a lender, because you have no protection at all. If you get a receiver appointed, then you have the force of a court order to protect you. If you just go in there and take over the property, you're opening yourself up as a mortgagee in possession. You're opening yourself up to all kinds of claims for damages to the property and failure to maintain it and environmental things that happen that it's really hard to defend against. So I don't know hardly any lender that would go in and take over a property without getting some court order. I was talking about how streamlined it is in Georgia. See, in Florida, you're doing the whole ball of wax at one time. You're filing a foreclosure lawsuit, and you're determining the amount of debt owed by the borrower to the lender, and you're getting a judgment and a right to foreclose against the property, and there's no issues about value. And so it takes longer, but it protects the borrower because it goes through a court process. Literally in Georgia, we have non-judicial foreclosure. And so if the bank decides that they want to foreclose in a commercial loan, not in a residential loan, unless the loan documents require a notice to the borrower, you literally prepare a document, which is called a notice of sale under power. You submit it to the official legal newspaper of the county in which the property is located. There's only one legal newspaper in each county. They run the ad once a week for 4 weeks, immediately before the foreclosure sale date. We only have one sale date a month. It's the first Tuesday of every month. We only between the hours of 10 and 4. And so if I'm representing the bank and they say we want to foreclose on this, I'll run my notice of sale under power. I'll go to the courthouse on the first Tuesday of the next month. I'll have the ad that I've published. I'll stand on the courthouse steps. Sometimes there'll be a big crowd like this looking at me. Sometimes there'll be one homeless person, literally, just sitting there watching you. What are you doing? Other times you'll be by yourself, totally alone. It's always raining on Foreclosure Tuesday, so you're holding an umbrella and you're reading the sale thing, and you just read the ad. it's like like an auction. And at the end of the auction, and there's no, I've done this, no one there but me, in a rural courthouse steps, and I'll say, on behalf of ABC Bank, I hereby bid $500,000. And then I'll look left and right, and I'll go going once, going twice, sold to ABC Bank. When I do that, the minute I say sold, literally, fee simple title to the property, it passes to the lender, the borrower has no right of redemption at all. I take out of my briefcase a deed under power, which is the conveyance instrument, in which which has already been signed by the lender, because in the loan documents, the lender was appointed by the borrower as his attorney in fact under a power of attorney to do the sale. So he'll sign the deed to himself. I'll walk into the courthouse, I'll record it, and it's done. And you think to yourself, wow, that's fraught with peril for a borrower. There's so much abuse. Well, the protection is that if that's all I do, if it was a $5 million loan and I bid $500,000, I don't have the right in Georgia to say, okay, now I've got a $4 million plus deficiency, and I'm going to sue the borrower for that until I go through a court process, which is not a lawsuit for a deficiency. It's called a confirmation action. It's where the court comes in and says, okay, tell us what you did, we'll bless the sale for you. We're going to look at two things in the confirmation action. Was the price that you received the true market value of the property? Well, obviously, the property's worth $3 million, I bid $500,000. I'm going to lose on that one. And did I properly conduct the sale? Did I meet all the requirements for notices, and was the bidding honest? Was there anything that was funky or chilled bidding? And so where we've seen a lot of battles actually this cycle is because values have been plummeting. Borrowers have been fighting confirmation actions thinking if I can win the confirmation action, which means not have the sale confirmed, he doesn't have a right to sue me under my guarantee or under the note. So where the battle has been is I go to foreclose now as the lender, I'm getting an appraisal as part of that foreclosure because I can't risk my 3-year-old appraisal. I'm getting a current appraisal as the value. The borrower is saying, I can't stop him from foreclosing. I'm getting an appraisal done right now also. Obviously, his appraisal is always going to show the property worth more. The lender's going to have to decide, okay, here's my appraisal. Do I want to bid in the full amount? I want to bid in at least the full amount. Do I want to go above the full amount? And remember, I'm what we call credit bidding. I'm not writing a check. He owes me $5 million. I'm bidding against the credit of that by just making a credit bid. A third party who shows up at that sale, and any one of you could show up, has to actually pay cash, but he can credit bid. So he gets done bidding, and now he goes to confirm it, and the judge says, okay, I'll now hear testimony on value. And the two appraisers will be brought up, just like on TV, and they'll be sworn in, and their credentials will be shown to the court, and he's this, he's that, he's got this certification, and he'll be questioned, and what did you do? What method did you use? I used the market thing, what comparables, blah, blah, blah. The judge will listen, and if the judge thinks that, that the borrower's value is more credible than he won't confirm the sale, and it's over. I mean, you've given your property back, but you have no personal liability. So that's why I said more and more people in Georgia now are suing first and foreclosing second. Because if you foreclose first, if you sue first and get a judgment, you don't have to confirm the sale. You get a judgment for the $5 million that he owes you, you can take that judgment and go foreclose and bid $1 if you want and own the property. On the theory that the borrower could always protect himself by coming to the sale and bidding $2 if he wanted to stop you. So. Well, I think if the sale is not confirmed because the court found that the sale was improper, one of the rights under the confirmation statute is the court can order a resale. So that if you screw up, and chilling the bidding it's a really tenuous sort of thing. But you're the lawyer for the bank and you're going to be foreclosing, and your phone rings and somebody says, "I saw your name in the notice of sale under power. What time will you be there, because you can be there anytime between 10 and 4, and you can be anywhere on the courthouse steps of the Superior Court. In Fulton County, our biggest county, the courthouse steps are probably 100 yards wide. In some of the rural counties, and there's 20 of them going up. In some of the smaller rural counties, the steps are not as wide as this podium, and there's only one step, okay? So you say, well, I'm going to be in the top right corner, and I'm going to be there at 11 o'clock, and he'll say, don't come at 11 o'clock. It's really crowded then. Why don't you come at 5 to 4? Most people will be gone by then. I'll be there, and I'll bid. And they go ahead and do that. If you're the borrower and you find out about that, that's chilled bidding. You haven't allowed the property to be bid for what may be the true market value because you've taken actions that are not in an open sale. But yes, if you don't get it confirmed because not on the value part, you can have a resale ordered. And so it's not a right of redemption, it's just the sale is not a valid sale. You have to do it again. Anybody else? Yes? It's a little different. Tax certificates is kind of a Florida thing. It's a little different in Georgia. We do have a big problem with people buying what we call a 5A, which is an abbreviation for some Latin term, furi facius. But essentially, and the fact pattern that you're talking about would be the following one. Somebody doesn't pay their property taxes. The county has a vested interest in getting property taxes paid because it's those taxes that enables them to provide services. Water, sewer, fire, police. If you have an occasional guy not pay his taxes, not a big deal. If you have thousands of people not paying their taxes, it's a real problem for the counties. And so about 20 years ago, companies started to pop up out of the woodwork because in Georgia, what the tax commissioner issues, and I'm assuming it's like a Florida tax certificate, is a tax FIFA. And essentially, people would come in and they would buy up big groups of tax FIFAs. And it was a great investment because by statute, you got paid a 12% return on your tax FIFA, which meant that prior to a tax sale, which you could then conduct, buying the tax FIFA, there was still a redemption right. But it was a great deal. Either the people were going to come and redeem their property, in which case you're going to get 12%. Where do you get 12% anymore? Or they weren't going to redeem the property, and then you could conduct a tax sale and own the property for the taxes. And so we're seeing a lot of that. We've seen people that have done syndicated purchases of tax FIFAs with investor groups that have come in, and there's one particular one. In a transaction, if I order a title examination to be done and I get the title report back and I see on my title report that the tax judgment was transferred to Vesta Holdings in Atlanta, it's like the kiss of death. I mean, Vesta's the biggest one. They're very difficult to deal with. You have to go through all these hoops to get them to if you're going to pay them with a 12% return, to terminate the tax FIFA. And there's been a lot of public pressure because it's pretty much prized on poorer people who don't have the ability to redeem their property or don't even know that their property's been tax levied because they just don't keep up with stuff like that. Is that kind of responsive? Okay. Yes? Well, I think what they're making them do is actually document the transfer of the loan through the process. There was this thing, I don't remember what the acronym stands for, it's MERS, it's like Mortgage Electronic Registration System, maybe? Is that what it is? And in the CMBS world, you know, because there were so many loans going into these pools, the way they were keeping track of them was on this electronic database, this MERS database. But MERS, you know, transferring a mortgage is clearly a matter of state law. There's no federal law that covers that. And you have to comply with state law, whatever it says. And so in a lot of states, but Florida being the leading state, there just weren't people, you know, because it was judicial, borrowers were smart enough to realize they could file objections to the foreclosures and challenge the lenders to produce a document that showed them as the legal holder of the mortgage. The lender would say, well, look, here's the MERS registration database, and you can see where it went from Main Street Bank to Wall Street Bank to securitized pool, and I am the master servicer of the securitized pool, and I own this. And the courts are saying, I want to see transfer and assignment of mortgage in recordable form recorded in Alachua County, where the property is, from Main Street Bank to Wall Street Bank. And then I want to see a transfer from Wall Street Bank to a special servicer, master servicer, before I'm going to let you do it. And so it's a problem. I don't know if they're going to come up with a global fix. I don't think they're going to. I just think banks are going to have to go back and fix their documentation. It's kind of a lawyer's full employment act sort of thing. So I'm not objecting to it, but I think it is. I mean, you got to follow the law, and they just short-circuited it to foreclose on a bunch of things. Yeah, I mean, theoretically, the note in a perfect world would be by endorsement or by a longe transferred the same way as but you're right, oftentimes they weren't done. And that's one of the reasons why it's really not an issue for us. We haven't had a problem in Georgia because, no one's, if someone thinks that they don't owe you the money, they're going to assert that in an action to enjoin a foreclosure. But by and large, you can go on the property records and you'll see the transfer of the deed to secure debt, and the party that's foreclosing is doing it, and you're fine. Yeah, it may well be that unless, we're getting into that kind of gray area between law and policy, and at some point, if somebody wants to say that it's going to be the policy of the state of Florida that we're going to allow these foreclosures because to not would be a travesty, it'll be interesting. I mean, no, I haven't. No. Yes.
Is there a basic qualification or criteria for selecting these receivers? Or?
Yeah, coming out of the recession, the most popular phone call that we got in my practice group was from everybody in the world saying, I'd like to be a receiver. What do I have to do? Traditionally, in real estate, receivers had often been people that were in property management. And so, somebody that was the principal of a management company with a lot of experience would also get it known that he was willing to work as a receiver. And he had the management company to back him, and then he would enter into a contract as the receiver with his own management company to manage the property. But coming into and out of the recession, suddenly you had real estate brokers, people, what went away? Well, what went away was investment sales. So you had the big real estate companies, Grubb & Ellis, may they rest in peace, they filed for foreclosure this week, for bankruptcy this week. C.B. Richard Ellis, Cushman & Wakefield, they had hundreds of employees nationwide that were in their investment sales arm. Well, there were no investment sales. They had all these people that were trained in doing economic analysis of income properties, perfect to be receivers. They had the right skill set. So they all wanted to be receivers. And so we spent more time introducing accountants, turnaround consultants, which was a real booming growth industry, brokers, investment sales brokers, to lenders. They all wanted to be lenders and get on their approved list. And now it's really more about the brokers all want to be on the approved list to do REO sale work, because we've gone through the first bit of the mess. We've done the pre-negotiation agreement. We've done the forbearance agreement. It hasn't been able to be worked out. We've taken remedial action, and now we own this piece of crap property. And what are we going to do with it? So, well, we're managing it. We're hiring management companies, but we want to dispose of it. And so every broker wants to have as a client a bank who has thousands of parcels of property that are sitting there that need to be disposed of and no people to do it. All right. Well, thank you very much. This, which isn't really very good. Oh, two things I didn't mention. I actually didn't mention the one thing that Wayne asked me. I put it on the last page, sale of a loan, which has been another thing we've seen a lot more of. Borrowers always think that a way to work out a transaction is if they can find some friendly people, sometimes family members, sometimes business associates, to come in. Maybe they can work out a discounted payoff of the loan or a loan purchase from the bank. There's been a lot of activity in note purchases, both single loans and portfolios of loans. Some of them have been done just the traditional way you'd think. You know, borrower will come in and say, look, don't foreclose. I can't pay you off, but I have somebody that will loan me 80% of what I owe you if you'll sell the loan to them for that amount and assign your loan documents to them so they don't lose priority against other creditors. And there's a bunch of things that go through their banks. Hate to be hoodwinked. The last thing they want to have done is to sell a loan at a discount to somebody who is effectively the borrower, the original borrower. So they're doing there's all kinds of disclosures about you're not affiliate, you're not related. But the FDIC, which has been around since the Depression and has two main roles. Everybody understands the basic role, which is to support our banks, to provide insurance for deposit accounts. But something they've always had and that they're really big in now is that they provide a market for the sale of loans, because as banks fail, and as we like to say in Georgia, we're number one. We have the most failed banks of any state in the union. When the FDIC comes in and takes over as a conservator or a receiver, they're selling loans, sometimes individually, but one of the things they've done is they've gone to these exchange sites. If you have time, go to dedex.com. You can look at it and get out. It's an exchange site essentially where people that are FDIC member banks are allowed to participate in online auctions of loan pools. And only FDIC member banks are permitted to do it. So it's been really kind of interesting because I've had a bunch of clients that have come to me in the last 3 or 4 years and have said, there's a shopping center in Clayton County and it's FDIC has the loan now, and I want to buy that loan because that shopping center's got, they want to own the shopping center, but they're going to get to it by buying the loan and foreclosing, but they're not an FDIC member bank. And so we've had all these kind of agreements entered into between FDIC member banks and the real people that want to own them, which I don't know that it's legal. Well, it's probably legal, but they could probably lose their ability to buy on DebtX. I've had a couple of clients that have paid $50,000 and $100,000 fees to banks to go in there and bid for them on DebtX, and then buy the loan with money provided by our client, and then transfer the loan to them down the road. But because there's a tremendous amount of value in those. So there's a lot of that going on. If you go to the DebtX website, it's kind of interesting. I mean, it's actually a national exchange for the trading sale by the FDIC primarily of loan pools. And you may see that, you know, there on a certain date, the entire real estate portfolio of Silverton Bank, which was a bank that was based in Atlanta, when Silverton failed, they auctioned off their entire participation interest in loans. Silverton had bought a bunch of participation interests with other small banks, and their whole portfolio of participations was sold in an online auction. So there's a lot of that going on also. That's pretty interesting, actually. All right. Well, thank you.